Hello, I'm Nick Hobden, partner and head of the employment team at Thompson and Partsmore, and I'm joined by my friend and colleague, solicitor Jessica Wells.
Hi, Nick.
Hi, so we're here to talk about what's involved in an employee bringing an employment tribunal claim, what it means for them to bring a claim, the process, the benefits, the drawbacks, and how we can provide assistance. Now, we're going to do this video in two parts. We're going to cover the first things that an employee should consider before bringing a claim, what are the steps they need to take through to actually commencing a claim, and what are called preliminary hearings. And then we're going to, in the next part, deal with the final hearing and some other useful stuff to think about as well along the way. So, Jessica, firstly, can I ask you about what are the first things that an employee needs to think about when bringing a claim?
So the very first thing that an employee should think about is, do they want to bring a claim? Now, claims can be incredibly time consuming, they can be expensive, and they can be quite emotionally taxing as well. It's a big decision to make. Employment is such a huge part of our lives, and bringing a claim against your current or ex-employer, it can be a huge decision to make. So that's the first step, and us and other solicitors are there to kind of aid and assist clients in making that kind of decision and helping them weigh up the pros and cons. So very first thing to consider. Then the most important thing after that is, can you actually bring a claim? So there are limitations to claims that can be brought. So the first sort of thing to consider in line with that is there are time issues that potentially need to be considered. So firstly, there's something called qualifying service. Now, for some claims such as unfair dismissal, an employee needs to have 2 years qualifying service. Now, that can't be rounded up, so if an employee has 1 year, 11 months and 25 days, that's less than the 2 years, it can't be rounded up. Now, they need to consider, have they worked for their employer for that length of time? Now, secondly, are time limits in bringing claims. So again, the example of unfair dismissal, an employee has 3 months less 1 day to bring a claim from that date of dismissal. So it's something that they need to consider, and if they're running out of time, then I'll come on to that point about bringing a claim, but they need to kind of get on with it to protect themselves. And time limits can be really tricky to work out. So with unfair dismissal, it's quite straightforward, whereas things like discrimination, there may be an ongoing time limit, and that might extend beyond the initial point of discrimination. So they can be tricky, and people like us are there to direct individuals as to whether their claims are within time. Now, the second thing to consider are costs. So I briefly mentioned a second ago that it is expensive. Now, some individuals may have cover under their home contents insurance. So some home contents insurers do provide cover for employment disputes. So they do tend to be limited to certain things, and they exclude certain types of disputes, but it's certainly something for people to consider, have a look at. It might be a huge benefit to them in reducing potential costs. So they're the main first steps that I would suggest an employee considers.
Okay, so I just want to pick you up on the costs point, because this is a very important point, of course, that if someone has a household insurance, buildings and contents cover, and it has legal expenses cover or cover to cover any type of contract claim, then potentially that insurance could cover an employment tribunal claim. Is that right?
It could potentially cover an employment tribunal claim, but it's important to note as well that the terms of insurers typically don't cover the full amount of costs. They tend to be limited, but in any event, it's certainly a help if they cover a proportion of the costs. As I say, tribunal claims are notoriously quite expensive, and any kind of assistance is always beneficial, and it's always something to consider looking at and just double checking.
Yeah, thank you. The other thing I wanted to pick up on is this problem issue of time limits. You mentioned that in unfair dismissal cases, it's quite straightforward. It's 3 months less 1 day from the effective date of termination, which is when the contract of employment comes to an end by the dismissal, the employee's last working day, either with or without notice, or potentially where the employee resigns on the spot. That could be the effective date of termination as well, or they may resign on notice. But with discrimination claims, of course, it's very, very difficult because, as you said, there may be several instances of, let's say, sex discrimination, which may happen over a period of time, and the 3-month time limit runs from the date when the act complained of occurred. But there could be several in a series of sex discrimination instances, all giving rise to claims. So do you take the last one or the first one, or what?
It really depends on what that looks like. So it's really unique to every circumstance, and that's why I say it's quite tricky to work out. And it's not something that you can just look at very quickly and think, right, that's it. That's when the time starts. It's typically from the last event of that discrimination. So in this case, the sex discrimination that occurred. But again, it really depends on what that looks like, who was involved, perhaps, and it as I say, it's really tricky, but typically from that last event.
So Jessica, thanks very much for covering that initial consideration of whether an employee should bring a claim. Well, what's the first thing they should do, assuming they've decided, right, I'm going to make a claim against my former employer?
Yeah, of course. So the most important thing is protect their position. They need to protect their right to bring a claim. So the first thing to consider is Acas need to be made aware of a claim before it's raised with the employment tribunal itself. Now that's something called the Acas early conciliation, and an employee or an individual needs to obtain an Acas early conciliation certificate. So the way that that's done, there's an online form that an employee needs to fill out, or it's something that we can assist with filling out. It's quite an easy process, and it just outlines the types of claim that they want to bring, who they're bringing it against, and it just protects an employee's position, and it extends, or it has a potential to extend the time limit of bringing that claim, because the process and the reason why this early conciliation process is entered into is that Acas acts as an intermediary between the parties. So it gives a period of time up to 6 weeks for Acas to go between the claimant and the respondent to try and form some kind of agreement before the tribunal process is entered into. And that can be potentially very beneficial for both parties, because it prevents the claim going any further. It reaches some kind of amicable solution potentially.
Yep.
There potentially could be some settlement in there. So it's a really important process to engage with, and it shouldn't be taken lightly. The benefits of it are that it is a lot faster than going down the tribunal route. It has the potential to take months, if not years. It can be cost effective. It's a free, impartial and confidential service to go down. So it's something that both parties should enter into willingly and knowing the benefits, and as I say, they shouldn't take it lightly.
Okay, now I'm going to pick up on two things there. Now, firstly, from the employee's perspective, you're saying that they have got to approach Acas for this early conciliation process with a view to conciliating through Acas, but they don't have to, do they? It's a step that they've got to take in order to bring a claim.
That's it, yeah, exactly that. So it's, if they want to bring a claim, it's something that they need to engage in. So it's advised, Acas advise that they do it. It's a process that it's beneficial that you go through Acas to bring a claim, because the early conciliation certificate produces a early conciliation certificate number, which needs to be placed on something called an ET1 form, which is the claim form that is then raised with the tribunal. So it's important to demonstrate that you've taken that initial step to resolve issues, to kickstart the claim. So it's an important process to start, and it's something that we certainly advise individuals to start themselves, or as I say, they can approach us to help with that kind of thing.
Okay, so to be clear then, the employee doesn't have to conciliate, but what they do have to do is they have to approach Acas to get that early conciliation certificate number.
Absolutely. There's when they go on to that form on the Acas website, there is a tick box that says, do you want to conciliate? They can say yes or no. That's really up to them. They don't have to engage into that. If they want to kind of go full steam ahead with the claim, they can do. It's just something that we would recommend, and that is typically recommended, that people engage with. It can be time consuming not to, it can be cost effective to go down that process, but no, they don't have to conciliate.
Okay. Now, another question on time limits again, because we've mentioned earlier that they've got to bring a claim within 3 months less 1 day of their termination of employment in unfair dismissal cases, or the date when the last act or series of act complained of a discriminatory nature. But here's the thing, they buy themselves more time if they go to Acas for early conciliation, don't they? Just explain how that works.
So entering into that Acas early conciliation, it essentially acts as a stop the clock process. So it stops the clock for 6 weeks, or up to 6 weeks, for Acas to try and conciliate between the parties. So yeah, it acts as a stop for those 6 weeks. Up to those 6 weeks, beyond then the usual time limits commence again after that time, but as I say, it only goes up to 6 weeks. So it can be less, it can be 1 week, 2 weeks, it really depends how the conciliation goes. But if it looks like it's not going to be successful after a week, then the time limit starts again from when conciliation has ended.
Yeah, and just to explain what that means, in reality, if, for an example, an employee approaches Acas before the 3rd month of their termination, and they get their Acas early conciliation certificate 6 weeks later, there's been no settlement. How long have they got then to bring a claim after that early conciliation certificate has been produced?
So in this case, if they've approached towards the end of that 3-month period, they've got essentially the remaining time that they would have had kind of left within that 3 months after the conciliation process has ended.
Or they've got another month, haven't they? Whichever is the greater.
Exactly, yes.
Yeah. Right, so once the early conciliation certificate has been produced, and assuming there's been no settlement, the employee wants to take their claim to the employment tribunal, what happens next? What do they need to do?
So in bringing a claim to the employment tribunal, there is a form that needs to be completed. It's called the ET1 form, it's the claim form, and that provides for the claimant to raise the names of themselves and the respondent, so typically their employer or ex-employer. They need to provide details of the claims that they're going to be bringing, so there's a tick box exercise that needs to be filled out. There is a section on the financial parts of the claimant's life, so that's how much they were earning, have they sought new employment, how much are they earning now, and there's some other really important pieces of information that need to be provided. Now the main piece of information is actually what is the claim about, what are they bringing, so it's not as straightforward as just ticking a box saying unfair dismissal. They need to provide details for the respondent to be able to respond to. So typically, separate to the ET1 form, there is a separate form that can be completed, and that's typically it goes into a lot more detail about the claim. It provides names, dates, potentially refers to documents, and that's called the particulars of claim. So that's something that we can assist with, and it's a much more in-depth document than just the very small space in the ET1 form allows. So once that's been submitted, the claimant will receive a response from the tribunal to say that we received your claim, thank you very much. They will then send that, the tribunal will then send that to the respondent. The respondent then has 28 days from receipt of that claim to respond, so they will produce a form called the ET3 if they want to contest the claim that's being brought, or claims that are being brought. And typically as well, a very small box for them to contest the claim, so they will also provide a separate document as well, which will go into all the details as to why they are contesting that claim. So again, they might raise dates, names of individuals, so it will battle against the original claim that's being brought. So once that process has been done, and once a response has been provided by the respondent, the claimant then will receive details of the response, so they're able to see that. And then potentially the process will lead into the tribunal's hands from then. So potentially the tribunal may require preliminary hearings to be entered into. So preliminary hearings are pre-hearings before the final hearing that potentially irons out any details that need to be finalised before the final hearing. They can potentially put in case management orders, so that could the tribunal could say, well, this is the timetable going forward up to the final hearing, when certain parties or both parties need to produce documents, when they need to agree a bundle, something like that. And as I say, it can be ironing out details as well. So in a disability discrimination claim, whether the claimant was actually disabled at the time, whether there are any time limit issues. So that's usually the next step, and there might be a few case management directions that are produced, but it's really important that claimants, well, both parties, comply with the directions from the tribunal. They need to be taken seriously. They will have time limits attached to them, and they really need to be taken seriously, because if they're not, then there is a risk that their claim or response may get struck out, and that their response or claim may not be considered going forward. So it's really important that any correspondence from the tribunal is thoroughly adhered to.
As you say, this is an important stage in the case before the full hearing and the final hearing. It's an opportunity where the tribunal can require both employer and employee, respondent and claimant, to disclose relevant documents in their possession. Often there's a requirement for witness statements to be prepared and exchanged and then sent to the tribunal. Sometimes it's useful to have a chronology or a list of people involved in the case. So that's all very important. And I suppose crucially, it's the list of issues on which the final hearing will be decided that really has to be bottomed out and identified very clearly, because if either side has missed an issue which they think should have been included, then they've missed the opportunity to do that at the preliminary hearing stage.
Absolutely, and as part of that, one of the directions from the tribunal will be to produce, or for both parties to produce, an agenda for any preliminary hearing, so for a case management preliminary hearing. So that will include whether there are any amendments required to the claim or the response, the number of witnesses that they intend to bring, so that there's quite a lot of detail in there that needs to be ironed out beforehand. And as you say, the list of issues, which really breaks down the claim to its fundamental parts: what kind of questions need to be raised, how will the tribunal approach it. So it's really important to assist both claimant and respondent, but as well the tribunal.
Good. So in this outline of what an employment tribunal claim looks like, we're going to pause there for this part of the video, and we'll see you next time when we describe the final hearing and other relevant things to consider when an employee is bringing an employment tribunal claim.